and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Welcome to Unpacking the Case, the property law podcast by David Jones Bold. This week, we're looking at a case that will be of particular interest to landlords, housing associations, and anyone involved in shared ownership developments. In Notting Hill Home Ownership Limited and Samoail and Others, the Upper Tribunal was asked whether shared ownership leaseholders could be charged for the upkeep of facilities that their leases didn't cover and that they couldn't actually access. The Tribunal's answer was clear. If the lease doesn't give residents rights over those facilities, landlords cannot simply pass on the cost of maintaining them through service charges. So what does this mean for service charge recovery, lease drafting and estate management going forward? Let's unpack the case. Hi, Richard.
Hello, Lizzie.
Hello. We are back with another news flash.
What a day it's been.
We're having a great day. It's a Thursday, which is always a good day. And we're talking about an Upper Tribunal decision from the 30th of June. And the case is called Notting Hill Home Ownership and Samoail and Others. It's all about subleasing and service charges, specifically in this case for blocks of flats, but there's also related issues for commercial leases. And it's an important one for landlords. So do you want to start with some of the background on this one, please?
As you say, it's a Upper Tribunal decision from June the 30th of this year. Basically, the Notting Hill Home Ownership are part of Notting Hill Genesis, which had been around since 1963, I think it was. We were big housing associations, but this particular premises was in Battersea. It was a development on the former John Milton School in Battersea, on Battersea Park Road in London, which they... Notting Hill Home Ownership had taken on a lease for 155 years in 2007 and then granted subleases, 125-year subleases to residential tenants who were on shared ownerships, so affordable housing basically. The whole development's called Viridian Apartments and there's 8 blocks altogether. But block V1 is where the shared ownership leases are, and the intermediate landlord being Notting Hill Home Ownership. And their leases didn't allow them to access the other blocks. They couldn't access the other blocks, and they weren't able to use the courtyard garden, which they couldn't get to, or concierge services, which used to be called caretakers in my day. And also a gym, and they couldn't use it. They did have obviously a flat, and they had car parking, underground car parking, and a balcony. Well, that was the sort of background. And for whatever reason, the head lease and the sublease didn't have the same service charge provisions. Seems sort of bizarre, and was commented on by the judge that. How this has happened is, basically unknown, because the head lease had to pay service charge liability for the development, and the development being the whole 8 blocks, if you like, plus any common parts, whereas the subleases referred to the block and the building. But for many a year, the Notting Hill Home Ownership had been charging the various tenants for the whole development, including the gym and the likes and the concierge that they couldn't use. And their service charge had gone up for a 2-bedroom flat in the block. In 2011, it was £1,700. And when the case started off in life, it had gone up to £6,200 per annum. It was actually in the national news. Should have mentioned that, Lizzie. It was a national news story a short while ago. And because the tenants, 25 of the tenants seem to have objected out of 38 altogether and brought an action under Section 27A of the 1987 Landlord and Tenant Act, which allows the tribunal to make a decision as to whether service charge, make a declaration as to whether service charge is payable or not in a flat. And that's some of the background.
So what's some of the issues on this one, and what happened in the courts?
Well, basically, the question is the development the same as the building. That's the argument, or the block. And I wasn't surprised about the decision. I mean, it's the same as the first tier tribunal decision. They quoted several cases, but most notably Arnold and Britton, which was a 2015 Supreme Court case, Lord Neuberger, giving one particular judgment. It was about ground rents. It's the case that actually started off all the discussion about escalating ground rents. Was Arnold and Britton. And that basically you should interpret contractual terms such as this in regard to the intention of the parties and what a reasonable person having all background knowledge would have been available to them and what they would have understood. And also they said, in Arnold and Britton, they basically said you take into account sort of things like the natural and ordinary meaning of the words and commercial common sense, the overall purpose. And also a pretty incomprehensible case called Chartbrook and Persimmon, which is all about overage, which is pretty incomprehensible in its own right, which said similar kind of things. You look at commercial common sense and what would a reasonable person have understood the terms to mean. And basically a reasonable person wouldn't understand that you would have to pay service charge for services that you don't have to, you have no ability to use. So although the head lease required the Notting Hill, totally different place, home ownership to pay for the whole development, including the gym and the likes, then the subleases didn't require them or didn't allow them to take that that service charge back, from the subtenants. Seems to be incredibly badly drafted, the whole thing back in the day when it was first. I was first, sort of set up this development. And it's a good reminder to check that the sublease and the head lease do the same thing. They tried to argue as well, did Notting Hill, that the subtenants, the shared owners would get some benefit out of this because it would mean that your neighbours had nice, tidy gardens and the likes, which is a nice thing to have. And the judge basically said, well, it is a nice thing if your neighbours have got tidy properties and gardens and so on, are all very slim because they go to the gym every day, but you don't have to pay for it. And so the subtenants didn't have to pay, and they got, they get the money back, backdated to 2018. That's one of the things it said. It said one or two other things as well, actually. I tell you about that.
Please, can you tell us? Yes.
They try to argue this is, I think that part is very much relevant to, leasing and subleasing generally, not just residential flats and the likes, but generally. But they also went on to say that there was obviously a mistake in the leases, if that was the case, and Notting Hill Home Ownership wanted the leases to be rectified, and the the tribunal basically said no. There's no rectification in this particular case. There's no mistake. It's just shoddy drafting. Should have thought about better. And they also tried to argue Section 35, subsection 2 of the Landlord and Tenant Act 1987, which allows leaseholders and flats, any one leaseholder, to ask the tribunal for a variation of the lease in various circumstances, but most notably if there's unsatisfactory provision for collection of service charges. And the tribunal said there's nothing unsatisfactory about it. It's you get your money for the things that the tenants, the subtenants are actually using. So again, I wasn't surprised about that. They finally decided that under Section 20C of the 87 Landlord and Tenant Act, you couldn't add the cost of the proceedings to the service charge as well, which again wasn't surprising. So a winner for the tenants in that particular case.
There we go. So why is this one so important, do you think? Why are we talking about it?
There's obviously a little bit of policy behind it, but I think that they're not unique. This Viridian Apartments 1 block is not unique like that. Think carefully in terms of drafting and making sure that the the service charge provisions in the sub-lease sort of correspond with the service charge provisions in the head lease, and why on earth they fell into that trap, who knows? But as I say, that part is not unique to residential blocks to flats and likes. That would be equally applicable in commercial. But I suspect there's lots of blocks, private sector housing associations, local authorities and likes, which may well come into that little trap. You just had these people, 25 of the flat owners, who were very persistent and clubbed together to bring an action which most individuals couldn't afford.
Well, thank you very much, Richard.
My pleasure, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.